Yes, doctor.
Yes. Or I wonder whether it's my timing which is impeccable, or my friend's timing which is impeccable. He appears to have completed just when I arrived. I'm grateful for the accommodation. I'm sorry, Melissa, I couldn't come a little earlier, but there has been no loss of time. I seem to be exactly on time. Now, Melissa, let me go one by one. And we've had a system which has largely apprised me of what has been happening. Some other leftover points my learned friends here will cover in addition. Melissa, let us just step back for a minute. I'm going to make pointed points for us and rejoinder. Let's just step back. What are we today here in? What is your lordship dealing with? Your lordship is dealing with 389. So my first question to myself, is there a section called 389? Obviously there is. Second question to myself, what is that section inserted for? For what purpose? To give a suspension of a certain act, conviction, etc., etc. What is the purpose of that section? The purpose of that section is, and can only be one, sole, that in cases where the conviction has a deleterious, serious, adverse consequence, why should your lordships, in the fitness of things, if your lordship so finds, not have the power to suspend it? That clearly is the object. Question number 4 to myself. Does 389 make difference, or does it make segmentation, or does it make categorization of the kind of offenses? Answer is clearly no. 389 is not offense specific. In other words, 389 cuts across the entirety. So it is wrong to suppose that there are certain offenses which are outside the purview of 389 or beyond the pale of 389 or somehow not contemplated as suspendable convictions or suspendable sentences. That very assumption is wrong. And the last question to myself is, how is then 389 operated? Not by looking at an act 8.3, not by looking at some section. It is operated by seeing certain parameters which my Lord has laid down. My Lord means the jurisprudence has laid down. That what are extraordinary circumstances? What are serious offenses? How, when, what, for what reasons, for what criteria would you suspend and would you not suspend? So that's my point number 1. Therefore, that's the first point. There is a section created clearly for suspension. The purpose and the rationale, the raison d'etre for that section is to give relief to a person accused of a certain crime so that the deleterious consequences of that crime are mitigated. And then, it is not that certain things are put in a schedule under that section which are untouchable. No. And it is not, it is section neutral, it is offense neutral. That's my first point. My second point is, that the courts actually have given us enough guidance as to when, how, and for what reasons will your lordship suspend. So the test is, extraordinary circumstances. Now, clearly, there is no section which says in this act, section 2, bracket E, extraordinary circumstances are defined as so and so. That's not the way it works. Extraordinary circumstances, fortunately, your lordship has made reasonably clear in the jurisprudence and the judgments. And this is the fundamental error of the submissions of the respondents in this appeal, because they assume or think that there is an exclusionary element in 389 which is untouchable. And they take the word serious to be a self-serving phrase, that what the complainant calls serious or thinks serious is serious. So, what is that jurisprudence on extraordinary circumstances? It's a very interesting and a simple one. Shyam Narayan Pandey educates us in the negative. What Shyam Narayan Pandey, which I'll be showing in a minute, does is, it educates us in the negative. It doesn't say what is the extraordinary circumstances by which your lordship may give. It tells your lordships on a principle of exclusion as to what are the circumstances, a few of them, where your lordships would not normally give. Even there your lordships can give, but would not normally give. So it does on a principle of exclusion. And it says so by showing that certain things would not be called an extraordinary circumstance to grant a suspension. By obvious fellows interpretation, all other cases are fit. Now there are two categorizations there, fellows. The categorization is not only on seriousness. One is what is perceived as serious, and there is law on that. The other is even if not serious, by way of length of punishment, etc., where it is moral turpitude based. Now let us kindly see the examples where it is thought that your lordships may not have extraordinary circumstances. But remember there, the caveat is very clear. Even there your lordships can give, have given in any number of cases. But your lordship will be hesitant to give. And this is very, very important. What is that, fellows? There is one death sentence. I'm being very specific. This is the case law. Second, life imprisonment. Third, imprisonment above 10 years or 10 years and more. Fourth, now these are serious. These are categorizations which are long and serious. There may be some offenses which are not so serious in terms of length, but they are considered serious in terms of moral turpitude. Namely, one is Prevention of Corruption Act. Now, in these cases, none of these cases, not one of them says that electoral disqualification is a serious offense, unless the disqualification is for one of these, one is murder, death, life imprisonment. So it's extraordinary that my learned friends are laboring and applying this to a principle of defamation, which is remarkable for the reason that defamation is nowhere in this list of any case which is considered, forget granting or not granting conviction, suspension, forget granting or not granting, etc. Not one of the cases suggests that defamation is the category of either serious or it is the category of moral turpitude offenses. Then I am asking myself, on what distorted principle are you, apart from a certain amount of dislike for the person concerned, you denying this? Then, Malas, just note, defamation actually on every test falls in the opposite category. It falls in the spectrum, which is the direct polar opposite. And therefore, it is most sad that it is being treated as a offense which is unpardonable, which is a serious crime. Number one. Why? Why? And not on one, some things fall in the opposite spectrum on 1 point or 2 points. Here, Malas, it is a very remarkable convergence cumulatively of all the tests. For example, one obvious test is it bailable? Number is, how many offenses does my Lord consider bailable which are serious? What is the very meaning of the word bailable, Malas? I'm asking myself.
That you have
Second,
pointed out, perhaps 26 is the offense bailable. Otherwise, all are 26 or 27 offense.
No, that is the second point. No, my Lord is right. That is the first point, is not that. First point is simply bailable. Let's forget everything else. Suppose your Lordship says bailable. Bailable broadly, subject to something, means that a police can grant bail. Normally, Malas, it will never be serious if he can grant bail to me. I don't have to come to a judicial level. Normally. Second, as my Lord just said, rightly, some 22 actually we have counted, 24, 22, where it is simple imprisonment. This is a very select category, Malas. Obviously, the statute, the legislature thought it fit to put it in a category which is less serious. There's no question of us having a, if I may call it, the word is, it's a wrong word, a very interesting word, mandatory simple imprisonment only. Can't go beyond that. Third, nobody has suggested in any jurisprudence that it's an anti-societal offense. It is anti-societal. Nobody. That's the third test. Fourth is it is non-cognizable. Now, Malas, how many cases does your Lordship have where all the four intersect? Your Lordship has some, not all. All four intersect. And your lordship is told it is such a heinous, serious offence that your lordships can't consider 389. So, without going into 10 years, without going into life imprisonment, without going into the case law, I would say the per se category of defamation, which has a convergence of these four things, per se makes it the simplest offence, and if 389 is not created to suspend that conviction, then it might as well be repealed. 389 will not find a simpler conviction to suspend than defamation, which is non-cognizable, which is simple imprisonment, which is bailable, which is anti-society, which is not anti-societal. Therefore, my learned friend's suggestion, which I am told he made today also, that because it is put in 8.3 and because there is an 8.3 disqualification, therefore it is more serious. No, on the contrary, that is a ground of irreversibility, which I am now turning to. These four tests are broadly noted in Subramaniam Swami's case. Your lordship will note the citation which is there. It's in our compilation at page 1. First case. Para 176 notes these four characteristics.
Para
176. Just check up. That is in non. And your lordship will note the second case, Shyam Narayan Pandey, which is in your lordship's compilation at page 135.
Para 6.
In that Shyam Narayan para 6 and Subramanian Swami 176, especially Shyam Narayan, these four intersecting elements of this offence are noted. And therefore, I submit that if there is a classic offence, which is the mildest form of offence, which must lead to a 389 suspension, then it is this. The third aspect is, and that I argued at some length last time, is irreversibility. Well, actually, 389 is a simple test. Your lordship is not deciding whether I am guilty or innocent. That the trial court will decide or the sessions court will decide. But your lordship is doing what your lordship does in every case, criminal or civil. Kind of a lose, as I said last time, wrong word to use in criminal law, but still it's the same thing, balance of convenience. That is this problem, is this hurt, is this prejudice irreversible? Every case, because your lordship cannot do the final and the interim at the same go, involves a certain interim decision and call to be taken by the learned judge. That call is based on irreparable loss or irreversible nature of the injury. Now, before I come to a couple of cases, or mainly one case, 2 paras, I want to ask myself, so I've done with the first part of the simple. I'm now on that's the nature of the offense. Now I'm asking myself, can there be something more irreversible than a disqualification which robs you of a status as a parliamentarian or an MLA? So forget this case, ask yourself the question conceptually. As I tell you, there are two kinds of persons, let us assume, who commit the offence of defamation. I am a member of parliament, he is a non-member of parliament, both of us commit. Well, it's the member of parliament in that sense has greater irreversible prejudice in that sense than the non-member of parliament because he loses his seat. That's a point in my favor, not against me. My learned friends, brothers, have completely misunderstood the point in my favor and are projecting it as a point against me. The loss occasioned to both of us is bad. Because he loses mental peace, he loses so many things. I lose all of that. But one additional thing I lose is probably the most irreversible. There is no answer to that. I argued it partly in the opening. There is no answer to that. There cannot be an answer to that. My learned friend can't invent an answer. Well, I have already a certain portion of my last session. I have already my role as a parliamentarian in committees. Well, as parliamentarians or MLA, same thing, function both inside parliament and outside. So when parliament is in session is not the only test. There are parliamentary committees. There are parliamentary papers. There are parliamentary interjections. They happen in committee meetings also outside of the session of parliament. Now, when is the last part of the last session he loses? Many committee meetings he loses. And the immediate next session he will lose in case he doesn't get a suspension. But that is his loss as a parliamentarian. Here again, there is an intersecting triple loss. There is a loss to him, naturally. He is there in public life to project the voice of a certain section of people. He loses that right. That's a great loss to him. And incidentally, I've had the privilege of being a chairman of many parliamentary committees. What your lordship sees in these cameras, real solid work is done in parliamentary committees. They say, Parliament at work is Parliament in committee. Parliament in committee is Parliament at work. A far greater degree of unanimity and convergence happens in parliamentary committees than what your lordship sees on the cameras in inside the House of Parliament. In fact, there were a couple of proposals some years ago, when they've introduced cameras for Parliament, that you should have cameras for committee meetings also. I personally vehemently opposed it. So many others opposed it. That whatever little good consensual work is being done, you don't want it to be lost by the glare of cameras. So a lot of work outside a parliamentary session is also lost to the parliament. That's one loss. Second loss is to the people of his constituency. They have an elected representative, Mr. X. He may be good, bad, or indifferent. It's their choice. It's not my choice, it's their choice. Their choice loses its voice. Their choice loses their voice. These are not mere empty rhetoric. These are practical. In a democracy, your lordship knows we live by fictions. When a decision is taken by 700, 800 people in parliament, it need not be that everybody who is elected them agrees with it. But the fiction is that you are elected and therefore you have the right to enact a law which is deemed to be their will. They are the electorate. So in the same way, on that fiction, that entire right of that collectivity known as we the people is lost. The third loss is, the third loss is to the nation, because ultimately what is the collectivity across, so one is personal, one is constituency, the third is to the entire collectivity of parliamentary democracy, because parliamentary democracy is made of a collection of those constituencies. Therefore, your lordship would have to consider, can any of these be reversed? We are on reversibility, balance of convenience. I gave your lordship two simple examples. Assume, now example number one is that what is already lost, we are now arguing on 2nd or something of May. So what is lost from the date till now is lost. It is that I can't think of any way in which your lordship can restore it. I mean, a court is only human. A court is not supernatural that can restore. How can a lordship restore it? Nobody can restore it. There's another thing. Suppose this lingers on even for a day. I mean, a day means any small length of time. The election commission is absolutely under no obligation that Mr. Singhvi is arguing here and Mr. Danavati is arguing there and there is something going on there. They say that this constituency will not go unrepresented. As I told you last time, that limit of time can be as little as 3 months. It can extend sometimes to 5-6 months. If the election is declared, and after that, there's another thing which happens. Once an election is declared, the normal window is about 6 weeks. The moment that notification declaring a by-election, not even election, a by-election comes, your lordship knows everything stops. Your lordship doesn't interfere on that old fiction that now you challenge after the election. So the entirety of that thing can't be stopped. Thereafter, Mr. Rahul is elected. Can I come and say, please unseat Rahul because your lordship was hearing my matter? Can anybody say that? Or your lordship says, now there's a third example. I've given a third example. Your lordships in the course of either before Mr. Rahul is elected or 3 months after he is elected, the primary sessions court acquits me. It's very easy. Tough luck, Mr. Singhvi, go and fight an election again.
Yes.
To make that balance, your lordship has a provision for stay of conviction. It is for that reason alone. Then there is a outer fourth facet. The cost on the exchequer of the election. Look at the concentric circles your lordship has. Personal core, collectivity constituency, larger collectivities of parliamentary democracy, and then the cost to the exchequer of having an election actually with a man already elected who has not completed his tenure, but who is subject to litigation, where Manas is arguing 389. Manas, this is a classic case. That is the real test. All this thing while learned friends are telling a lordship about how serious it is, or the evidence is only to satisfy lordship's conscience. Ultimately, Manas, the lordship test is only this. Now, in that light, Manas, just see two paras of a judgment called State of Rajasthan versus Salim Khan, 2015. Just para 21 and 22.
2015.
2015, volume 15 SCC, 666.
Which para you are?
Para 21 and 22. No, for the court. May I read minus 21?
Yes.
Page 7.
If some foreign country is not granting permission to visit the country on the ground that the respondent has been convicted of an offence and has been sentenced for 5 years of imprisonment under the Indian law, the said order cannot be a ground to stay the order of conviction. If an order of conviction in any manner is causing irreversible consequence of injustice to the respondent, it was open to the court to consider the same. Mark this line. Irreversibility will vary. Your lordship is the judge of irreversibility. If the court comes to a definite conclusion that irreversible consequences and injustice would be caused to the accused, which could not be restored, it was well within the domain of the court to stay the conviction. No such ground has been shown by the High Court while passing the impugned order. Further, we find that now more than 1 year has passed and there is nothing to record that the respondent has to visit the UK again. That's for shooting of a film. That's the facts of that case. For the reasons aforesaid, we set aside the impugned judgment passed by the High Court of Rajasthan and Jodhpur, Salman Khan, etc. Remit the case to the High Court to decide the matter afresh. We open to the respondent to show that if the order of conviction is not stayed, it will cause irreversible consequence injustice to him, which cannot be undone if he ultimately succeeds. We open to the state to oppose each prayer. Well, as I am saying, these are actually much weaker cases compared to mine. Ex hypothesi, the nature of the post I hold is such that the consequence is completely irreversible. Ex hypothesi. It is something which doesn't need to be stated. It cannot possibly be restored. Now, let us kindly see Navjot Singh Sidhu, para 20 to 23. Now, remember, this was a murder charge.
Last order of Supreme Court under which he has to undergo conviction and he has to remain in jail.
Now, I had the privilege of arguing that for him, that 1 year thing. But when the matter started,
yes,
this was a case of my learned friend was there also.
Was by case note when he was acquitted. Review Mr. Singhvi.
It started with what is the 302 charge. The charge basically, let's forget what is 302, 304. I'm asking myself, am I anywhere near 302, 304, and 30? Am I anywhere near that? I'm in a different world
And
as far as those sections are concerned.
subsection 4 was live when Navjot Singh Sidhu signed, which was subsequently declared otherwise.
Yes, yes.
So that-
No,
but then he
no.
offered to resign. That's all that happened.
Kindly see what is para 20 onwards. I am now not on that. The law is now very clear in 83 and 389. Now we are on the point that it is wrong to think that the moment you are convicted, Parliament becomes a barred area for you. That's not the approach. Under controlled conditions, you are still entitled to be in Parliament. That controlled condition now is suspension. It was suspension then also, but there was an automatic continuance given, which law was changed. It is not that your lordships has well as a completely barring effect. That's what I'm reading. Mr. Dwivedi, for the complainant, I'm reading para 20 minutes,
yes,
has submitted that in order to maintain purity and probity in public, this was the argument which was rejected. Probity in public bodies, criminalization of politics has to be stopped, and persons who have been convicted of any offense should not be allowed to enter Parliament. Now, this is actually the approach which has to be seen. He has elaborated his argument by submitting that irrespective of quantum of sentence, if a person is convicted for an offense referred to in 8.1, where the punishment imposed may be only a fine. That's exactly the point I'm arguing. A simple imprisonment, small punishment. Even then, Mr. Dwivedi says, no, doesn't matter. Out, you're out. A person will incur the disqualification from the date of conviction, which will remain for a period of 6 years. And this evinces the intention of the legislature that convicts should not enter the precincts of parliament or legislature. I'm on this narrow issue. I'm not arguing the current issue. I am saying the precise argument was raised twofold. One, please don't look at moral turpitude and seriousness. Any offense and zero tolerance, you can't enter parliament till you get an acquittal or you're out completely. That was the argument. In our opinion, the contention raised cannot be accepted. The preamble to the Representation of People's Act of 1951 is quoted, and just see that, fellows. An act to provide for the conduct of elections to the Houses of Parliament, to the Houses of Legislature, qualification and disqualification of membership, corrupt practices, other offences, etc. The Act provides not only the eligibility and qualification for membership of the House of People and Legislative Assembly, but also for disqualification on conviction and other matters. Parliament in its wisdom having made a specific provision for disqualification on conviction by enacting 8, it is not for the court to abridge or expand the same. The decisions of this court rendered in Ramanarang and Ravikant Patil. Now, my lordship, remember when I opened it, I gave a lordship these judgments, and I gave the pages in the test also. Having recognized the power possessed by the Court of Appeal to suspend or stay an order of the conviction, and having also laid down the parameters for exercise of such power, not possible to hold as a matter of rule or to lay down, not possible to hold as a matter of rule or to lay down, that in order to prevent any person who has committed an offence from entering Parliament or the Assembly, the order of conviction should not be suspended. The courts have to interpret the law as it stands and not on considerations. Your lordship is really being argued today by the other side as if this is some kind of a heinous situation where the moment I'm convicted, you can't touch it, he can't enter Parliament. The whole law of suspension is made only so he can enter Parliament. So that all these 4 tests of personal laws, constituency laws, parliamentary democracy and cost to exchequer are balanced depending on the context of a case. Shri Dwivedi has also submitted that once an accused has been convicted, it is only the execution of the sentence which can be suspended, and the order of conviction cannot be suspended or stayed. This is one again. Now your lordship is hearing conviction stay because it's been settled by the Supreme. Otherwise, the argument was you can't stay conviction. You can stay a sentence, so what? Now see how it's answered. Go down 5 lines in para 22. The contention is that the appellant would not be absolved of the disqualification even if an order of suspension or stay of the conviction is passed by this court. We are dealing here with the limited question, the prayer made by the appellant for suspending or staying the order of conviction. We are not required to adjudicate upon the question as to what will be the effect of the order, and further whether he will continue to be disqualified for the purpose of contesting the election, even if the prayer made by the appellant is granted, as such an issue is wholly alien to the present controversy, which can arise only in an election petition where the validity of the election may be called in question. Now, whether he can fight an election in a particular election petition, what ground somebody will take, I don't understand why anybody should agonize on that. Then, the very last part of para 23, because Mr. Dwivedi made a 3rd submission. Just see the last 5 lines of para 23. It would be a sublime public policy that the convicted person is kept under disability of conviction instead of keeping the sentence of imprisonment in abeyance till disposal of the appeal. In such cases, it is obvious to be highly improper to suspend the order of conviction of public servant, which would enable him to occupy the same office which he has misused. This is another point, Wallace. Suppose, Wallace, I am convicted of an offence which involves the very chair which will be activated if your lordship stays. Well, I can't think of it. Suppose, Wallace, the offence involves, Wallace, something very unruly or slapping a servant while I'm sitting inside Parliament on a particular chair. your lordship may have a consideration that reinstating me in parliament will activate that very offence again. That is not the case here, is what the court is saying. Certainly, it is not the case in my case at all. Cannot be the case. Namely, your lordship's stay of conviction enables me or puts me in a position potentially to repeat the offence. Now, let's kindly just look at a few other things. There is no prima facie finding of relevance. I will call it as relevant prima facie. There are findings. Relevant prima facie finding, which will disentitle me to stay of conviction as far as the Sessions Court is concerned, and hardly any in the trial court. I'll give you lordship an example straight away. What appears to have weighed in writing in the Sessions Court, and your lordship saw it with me last time, your lordship knows the papers, is A, that the derogatory remarks are made against a personage as high as the Honorable Prime Minister. I entirely agree. That would be a relevant consideration provided any of the persons named had been a complainant. Nobody is denying that the position is very high and sovereign, but we are not concerned with that complaint. So that consideration, how is it found place in the Sessions Court? I don't know. It appears that it's been colored by that, and that is an irrelevant consideration. With the greatest respect, that's an irrelevant consideration. Yes. Since there is a direct bar, I cannot proxy prosecute. There is no proxy prosecutor, I prosecute for him. The whole reason of this 13 crore business, I argued at great length last time, I don't want to repeat it, is because he is not prosecuting, the complainant is not the person named in that statement. That's why this 13 crore business, one in the class, one person in the class is brought in. That's consideration number one in the Sessions Court. Second consideration is that because the accused, me, is a public servant, I need to be dealt with more sternly. This is found in both the courts. With great respect, that is very unfair. I gave a simple example. Forget this case again. Take a case where Mr. Rahul commits an offence and Mr. Singhvi commits an offence. If you're identical, you're not supposed to assume it is identical. But if Mr. Rahul's act, not offence, Mr. Rahul's act is not an offence, then Mr. Singhvi's act cannot be an offence, merely because Mr. Singhvi is a public servant. I hope I'm clear. It is the act which has to be an offence, not because Mr. Singhvi is occupied. I understand, Malas. If your lordship finds Mr. Singhvi guilty, then your lordship may give us a little more punishment because he is holding some position as a public servant. But that can't be the test, fellows. Liable to be dealt with more sternly. There is no question, fellows, that if it is, you have to see individually whether a statement where no named person is a complainant is liable to criminal defamation because you are one amongst a class of 13 crores. That's a legal issue. It doesn't matter how high the person is, and it doesn't matter whether the accused happens to be a public servant or not. The third, is that a speech given during a campaign stands on a different footing. Look at the errors. It's writ large, the error. As a matter of fact, your lordship gives a little more license. The lordship sees the kind of things being said. I don't support most of them, this way or that way. But in the heat of the moment in a campaign, 19(1)A acquires a fuller bloom, not a lesser bloom. Well, it's not a wilting flower. It's, if at all, a more blooming flower. Well, the impugned order seems to think that people will be more subdued during the course of an election campaign. It's just the opposite is true, Malas. If there is a free speech right, nobody is saying, Malas, that because I am giving election speech, I can violate Malas defamation law. That's not the point. I am giving the one by one reasons given by the learned judge. Reason number 1 is wrong. Reason number 2, I'm now on reason number 3. Reason number 3 is there a speech given during the course of election campaign on a different footing. No! You have to individually judge, as I said, same test, whether his statement is defamation. If it is, then whether it is given in a speech or not, it's equally culpable. But if it is not, the fact that Rahul said it in a speech will not make it more culpable, Malas. Then, Malas, the fourth reason is related. The complainant, being an ex-minister involved in public life, certainly suffered harm in his reputation. That's the fourth reason given at page 69. Your Lordship has seen these reasons.
Yes.
Huh? Now, Maharaj, actually, again, the opposite is true. Of course, apart from the thing which Your Lordship has said repeatedly, one of the greatest qualities when you're in public life is to be thick-skinned, not thin-skinned. Thick skin is a great attribute and a great virtue in public life. Nobody, Malas, has the business of being oversensitive and say that I have been in public life, I'm an ex-minister, but I'm so sensitive that the moment somebody sneezes, I feel. Here, Malas, this person is aggrieved and hurt because he's 1 out of 13 crore people, is what he says. But that apart, yes. Yes. And Malas, therefore, this whole approach that he, Malas, being an ex-minister involved in public life, should be in that sense slightly more protected. Just the opposite is true. As they say, if you go into public life, you are submitting yourself, as they say, to the brickbats of public life, and you must have a little more thick skin. The fifth error in the same page, same sentence, 69, same page, is Malas, speculation, pure speculative findings, pure hypothetical findings. And one sentence makes it clear, Malas. Such defamatory remarks, he's talking about the complainant, Malas, the ex-minister. Such defamatory remarks, I'm reading word to word, would have certainly harmed his reputation and caused him pain and agony in society. That's not the test at all. The test is not to find that man who's the weakest link in the chain, who's hypersensitive, and say, look, all these people here would not be harmed. But that one man at the end of the room is so hypersensitive, he might have been, he would have been. And therefore, I will apply the law of defamation, his test. Because would have been harmed means, what is he harmed? What is he shown? He's only got one sentence case. My name is so-and-so, I am a class of 13 crore, I am also defamed. At the end of the day, that's the whole case. That, fellas, is a purely speculative, hypothetical, incomplete kind of an allegation. Forget the proof. Then I made my point about identifiable class. I'm not going to repeat that. I've given out the case law. That is the single most jurisdictional important point in this case. Jurisdictionally, fellas, the whole law of defamation was never intended. I made it in great detail last time. I'm in the jointed. I'm not repeating. Your Lordship is being asked to do violence to the concept of an identity. How can a class of 13 crores be an identifiable class? By very definition. We have argued all the names. I've read the evidence to Your Lordship. I mean, that would be really repetition. But this is directly the heart of the matter. Law says directly, Subramaniam Swami says directly, identifiable class, para 176. Yes. Now, any application of that in any which way, as a matter of fact, Your Lordship has got smaller classes. This is the first case I'm coming across where the class is defined as 13 crore people.
Question not answered it on this one. It can't take in its embrace.
My learned friend, I read the written submissions last time. My learned friend argued in the sessions court. I read the written submissions. Written submissions specifically make this point. He orally argued it. The judge notes it. The learned judge notes it. There's no answer. There's no answer. If this is correct, then there is a jurisdictional error. So, I defame him by name, he doesn't file. He files saying that by defaming him by name, I'm defaming the entire class of people standing here. That's the whole thing.
In the order, it's not answered.
It is noted in particular in para small Roman 3 at page 67 of the learned sessions court order. In the revision 5. In the revision 5. I did read it last time, but I'll just remind again. Yes. This I told you last time again, but I'll repeat it again. This is an important point because point taken, point noted, but not answered.
Yes.
I'm only on
last occasion you have pointed.
I am grateful.
67, 68,
no,
69.
I'm grateful. I raise it. You can reject it. You can say it is wrong because of 1, 2, 3. You've not dealt with it. I can't show negative. Where have you dealt with it? You've not dealt with it. Then, Malaj, the learned appellate court has suddenly relied entirely on this magic witness, which I told your lordship last time, is this Yaji. And my learned friends say that he was, the only virtue he has is he was present. Your lordship noted me last time at great length I dealt with Yaji. Malaj. I showed you the pages also.
Yes.
But just to remind lordship, two very simple things on Yaji. Malaj, Yaji, your lordship will note, is a person who suddenly appears like a magic wand 2.25 years after the complaint. Point 1. Point 2, he is not in any list of witnesses. Point 3, he starts his deposition, and your lordship saw with me page 44 to 46 of the compilation last time. I'm grateful. He starts by saying, I am a very strong pillar of the BJP. I have been for 40 years with the BJP, 45. I am now the cultural advisor to the Karnataka government. I have worked with the complainant in this position. I have done so many posts. A man, Malaj, with that background appearing 2.5 years later suddenly, without being in the list of witnesses, Malaj, it's very easy to make a frame of conviction on that. Now, this all I showed to your lordships, the written submissions, page 666. Page 666, written submissions. Directly the point, same thing, taken again by my learned friend Mr. Chima, not answered, not dealt with. But Malaj, the learned court fully relies on Yaji, doesn't deal with any criticism of Yaji. As a matter of fact, Malaj, everything else comes down to Yaji, boils down to Yaji, because
he has said only Yaji. He says electronic.
Now, Malaj,
today.
The answer here, just see the irony, Malaj. There is a whole host of witnesses. They are named in the beginning. None of them is found of any relevance. Most of them have not been there, they have not seen. Yaji appears, as I said, 2.5 years later, 2.25 years later. He's got a completely contradictory background. He obviously cannot be a sole reliable witness. Of course, he can be a witness if your lordship finds lots and lots of corroborative evidence. But Malaj, the main thing was the documentary evidence. The learned judge, I showed this also to your lordship last time, brushed aside in 2 sentences saying, yes, it is there. We will see it at the end of the trial. We will see it later. So documentary evidence is out. Yaji is in. Credibility, believability, corroborative is 0. The documentary evidence, if it is inadmissible or not valid, had to be dealt with at this stage. Because you are using Yaji to convict me, to deny me non-suspension of conviction, then documentary evidence can't be brushed aside like that. That's the point.
Lord, today also, Mr. Nanavati has only.
And my lordship has heard today, I was told when I was coming in the car here, that Mr. Nanavati's prime witness is the magical Mr. Yaji. Rightly, well, I mean, he cannot find a new witness now. Whatever is there is only this. With all his forensic ability, even he can't find a witness.
I don't want to eat.
Malas, therefore, even today, your lordship has got only this Yaji. He's a very infirm basis to not give me suspension of sentence. The sessions court, forget the trial court. I will win by trial, I will lose by trial, etc. The sessions court has to deal with it, Malas. Otherwise, what's the point? Then, Malas, kindly see that just a few more things will be done. I have made the point about the 65B certificate.
Yes.
Your lordship has noted it down.
Yes, sir.
It is well considered a technicality, but there are case after case after case, especially after Justice Nariman's judgment of the IT Act, that it's a mandatory provision. It's not that it's just something your lordship thinks it's technical and brushes it aside. Please produce 3 things. 1, maker certificate prepared by the maker of the CD. There is a CD, there is a maker of the CD, and there is a certificate. Where do the 3 match? Please show to the court. And the certificate issued while producing the CD in open court, it is admitted in writing at page 52, 53 of the CC that the CD was in open condition. Open condition, my lord, remember. Well, let me come to a more important point as I wind up, fellas. The more important point is that your lordship, fellas, ultimately, I have, fellas, the duty to, fellas, request my lords to consider and decide the suspension one way or the other. Fellas, at your lordship's immediate and earliest convenience. Well, I am here seeking a stay. I am gravely and irreversibly prejudiced without a stay. In my humble and respectful submission, Willis, it brooks no delay. We have now, everybody has argued. Your lordship, Willis, may kindly take a call this way or that way. Your lordship, Willis, may appreciate that denial. And of course, my lord is entitled to do one other thing subject to that. My lord is entitled to give an interlocutory decision and then a final, which is not normally done. I'll be very candid, not normally done. But Willis, some decision which clarifies my status today is vital. According to me, your lordship has heard us both at great length. Your lordship has seen at this level at 389, my lord is not a trial judge or a conviction judge or a acquittal judge. Your lordship is a 389 judge at the moment. Your lordship has seen enough. Your lordship should, come to a decision one way or the other. That is, my humble submission, because that justice would be required. Yashwant Sinha's case was, a Supreme Court order. It was in existence at the time of sentence. Now, that is what they are saying. I am asking myself one question, on Yashwant Sinha's case.
671.
Yes. This is fully dealt with at page 671 of my written submission. We will just turn to that for a minute. Because this is again something apart from Yaji. My learned friend relied a lot on Yashwant Sinha. I repeat, my experience is more limited. There are people here with criminal law more experience. I have yet to find a conviction in defamation at all, or if at all, more than 3 to 6 months. To say that maximum punishment is desirable, what is it desirable for? It's a first-time offender. How is maximum punishment desirable? And how many defamation cases has the lordship found where 2 years is imposed? I mean, your lordship, in the sense, appellate court, but it's coming from below. Your lordship doesn't hear the trial. There is no defamation case that I know where the maximum punishment imposed for the first time. And your lordship is told that we have to cite a case to show that this is the most apposite punishment. Yashwant Sinha cannot be an apposite punishment test. Now see, 671. Written submission. Just turn to 6. But there is not a single reason given factually or contextually as to why Yashwant Sinha mandates that your lordship gives a maximum of 2 years, because 1 year, 11 months and 29 days is not enough. Therefore, give 2 years to a first-time offender for a bailable, non-cognizable, anti-societal offence. There is no reason given to your lordship. It's just said Yashwant Sinha. Now, kindly see 671. I mean, Singh, it's not Yashwant Sinha. I'm told it's Yashwant Singh. I see.
Yes.
The same man.
Yeah.
It's the same. The political.
I have not argued that.
The most disturbing, just see 671. I thought there's a mistyping here. It's Singh here. It's actually Sinha. The most disturbing feature of sentencing part is the manner in which the prosecution placed reliance upon the judgment in Yashwant Singh and the uncritical manner in which the court readily signed the dotted lines. It has been pointed out in the memorandum of appeal that the said judgment would not have any bearing or relevance to the question of sentence in the present case. Now, this is the answer. Because the law applicable to the present case does not permit reliance upon observations made in a case of contempt of court. Your lordship is doing contempt of court, well as apples and oranges, or well as bananas and oranges. However, the real pain of the appellant lies elsewhere. The questioned speech relating to the institution of the present prosecution was made on 13th of April. The name of the appellant figured in the Supreme Court because of the alleged content much later in the year. This point I made, 6-9 months before and subsequent. The appellant was warned and told to exercise caution in future on 14/11. It baffles comprehension how, for a warning on 14/11, the appellant could be expected to be wiser on 13/4. Retrospectively, I said last time. Therefore,
So they have said.
well, it's the what is recorded in the order is that when I'm giving you something more because you already stood warned. On the date of giving you the punishment, Yashwant Sinha being present is neither here nor there. It's irrelevant. The jurisdictional error is, fellows, that the trial court is saying, I am punishing you, Mr. Accused, because you were earlier warned by the Supreme Court. You stood warned. The dates show that, fellows, there is no correlation at all. It's much later. Therefore, the answer can't be that on the date when I'm giving you the punishment, Yashwant Sinha has come. It's irrelevant, fellows. The 2 and 2 don't add up together. Whereas I would say, fellows, at the end of the day, just give me a minute. Just give me.
In keeping with
Don't worry. Don't.
my apology.
Unless this, I will move the application for suspension of sentence. Suspension of sentence, fellows, here, your lordship. Perhaps here, your lordship need not grant, fellows, for at least till the rising of the court.
Perhaps we are not now.
Till the rising of the court, your lordship need not suspend the sentence.
Another even conviction in the state.
Malas, if Malas, these considerations form a part, as I've shown, then Malas, it becomes very, very, well, I've also shown a whole set of 6 circumstances of vitiating of the trial. This Malas raises a grave doubt and apprehension about the purity and the fairness of the trial. I would beseech my lord, Malas, this way or that way for your lordship to decide the matter and give Malas quietus to this. And any delay of a single day, Malas, would Malas cause us.
In fact, now, therefore, we have made clear that we have heard total all the parties, and now we are keeping for judgment only.
I know,
During
Malas, I'm making one.
holidays, we are using all these materials, and we are finally deciding. That's
Malas,
all.
there is only one request. There
Yes.
is only one request. I mean, I hate to
And
make.
today again, the Honorable Apex Court has raised the very issue in the case of Muhammadullah Azam Khan.
Yes.
And the court has kept this matter in the month of July, where they have raised the very question.
Well, I am the counsel there.
Yes,
They listed today.
therefore,
three
I have
item
read
18.
that. Therefore, I am
I
now.
was to submit
No,
that,
no,
but
no.
may not, it
No,
is
no,
all,
no.
once it is sub judice,
The
it is
court
sub
has
judice
already
either
posed
way.
that very
No,
question. And what is the offense in that Muhammadullah Azam Khan?
Murder.
No murder.
Well, not murder. Sir.
Not
Grievous
murder.
hurt.
He
Grievous
is
hurt.
just sitting on the road with his father. Therefore, the
No, Malas,
FIR is registered
Grievous,
against
grievous
him.
hurt. Grievous hurt. Grievous
That is
hurt
in
case.
the second.
10
But
years.
in the first offense, it was registered as
No, Malas,
he is
I-
only aged 15 years at the relevant point of time.
Malas, he is given 10 years there, and the High Court suspended the conviction. We are respondents in the Supreme Court. The other side, complainant has appealed. And that matter was today listed as Court 3 item 18. I was to
That is
argue it,
what I
but
have
I have
read.
come here.
Hurriedly, and
What
therefore I
I
am
in
just.
mind was yesterday's matter before Malad when Mr. Sipal argued.
Yes.
That was a different matter where Malad that's kept in July. That's different than
No,
this.
no, no. Today, well, I don't know what happened when I came here. Today, matter is listed before court number 3 is Justice Joseph's court. Where
No,
Malas,
that
I
is
had-
not the matter yesterday.
That
Ah,
was
that
yesterday.
is now
that's
That
a
is
different
when
one.
the son
But
was sitting
anyway,
with
Milord,
his father.
that is all,
No, but-
they are all
but- but
pending.
I'm not concerned. I'm on a
Arguments
different
are
part.
going
No, I'm on a different. No, in that one, the sentence stands suspended. The matter which I
Yes,
am doing.
Kerala High Court
Where the
did that.
where the High Court of Allahabad has rejected and refused to entertain.
yesterday.
Therefore,
That is-
they are
that-
approached.
That's right, but then I can equally cite. No, kindly see. I can equally, I'm entitled to cite
Yes.
that the Kerala High Court suspended it. After suspension, for 1 month, the Malas Lok Sabha did not allow him to enter the. We Malas moved an application to Court 3. On the day I moved the application, the Lok Sabha Malas came through Mr. Mehta and said, today we are allowing him to enter. So the disqualification lifted. It was immediately stayed and lifted. Now, Malas, I have a different unpleasant duty to perform. Malas.
Yes.
I don't want to. Malas, it's my duty as a counsel to Malas, request my lord to consider giving us Malas, an order this side of the vacation, because
This
Malas,
is not possible. In fact, when first occasion I have clarified that on 4th I am leaving the country, and therefore I am unable to
no,
pass.
Malas, that is true.